Hey, hello everyone. I am hoping you all are good and fine. Please let me know in the chat box is everything is fine. I am audible or visible. If yes, I am audible or visible. So please first of all confirm me in the chat box. Then I will start the today's session. And what we are going to cover in this session, we are going to cover a very important unit, that is your Civil Procedure Code 1908 important practice set questions. Yes, the Civil Procedure Code is quite important like your Constitution of India. So we will do practice of lots of important question in this session as well. So yes, this session is very important from an exam point of view. Yes. So now without wasting any more further time, we are starting the session. So what we are going to cover, sir, and which unit that we will going to practice in this session. So first of all, a very happy new year to all of you guys. This is your 1st of January. I am taking your class for the SEBI Grade A paper number 2 under your phase 1, and today we are going to cover Civil Procedure Code 1908 important practice set questions. So all the questions will remain very important from exam point of view, and this question practice set question will give you the immense conceptual clarity as well as the practice of lots of questions that you can find in your examination, that's which is scheduled on your 10th of January 2026. So please do like this session as well as share with your friends and the colleague, those who are preparing for SEBI Grade A under the legal stream examination. And yes, don't forget to subscribe the channel. So please do subscribe the channel as well. And yes, you all are required to do participate in the chat box. And if you want to get a free PDF, if you want to get a conceptual clarity and the conceptual understanding for your paper number 1 and the paper number 2, so for that purpose you can download the application of Oliveboard. So just go on a play store and you can simply download the Oliveboard application if you want free mock test, if you want free e-PDF notes and your e-learning notes, so you can get here. So now we are starting with our practice set question, but before moving ahead, if you want to check out the conceptual classes and if you want to get the conceptual notes, so yes, you can get the conceptual notes in your SEBI Grade A complete course. So just download the application of Oliveboard where you will find all the conceptual notes as well as the conceptual classes for your paper number 1 and the paper number 2 for your phase 1 examination. Now guys, if you have any kind of doubt, if you want to connect with me 24 into 7, you can connect me here. That is, this is your Telegram channel. So if you have still not been joining our Telegram family group, so just scan this barcode or else you can search the Chartered Ajay Thakral on your Telegram. Just you can join in my Telegram channel as well. Now what we are going to cover in this session, sir, as you know very well, your phase 1 classes, your phase 1 examination schedule on which date, sir? That is on 10th of January 2026. So almost, if I'm talking about, we have left only 9 days, and within these 9 days we have to cover each and everything in a very perfectly manner, as well as we all are required to do the participations of all the practice set question that are important and that may be asked in your examination. So 10th of January 2026, as you know very well, it's the date of your phase 1 and under the SEBI Grade A exam, and on the 10th of January 2026, yes, only then you will able to write the 10th January 2026 exam when you have the conceptual understanding of each and every type of units, as well as you have a lots of practice in the questions as well. Only then you will able to write your exam in a perfectly manner. So yes, we have left with the Constitution of India. So the next class we will cover the Constitution of India type of question. We have already completed the contract law. Now in this session, this is your today's session. So in this session we are going to cover the Civil Procedure Code 1908, as well as we have already covered the Transfer of Property Act practice set questions. We have left with administrative law, law of tort, as well as your Consumer Protection Act 2019 we have already covered, arbitration and the conciliation act we have already covered, and the Limitation Act 1963 we have already covered. So we left with only the 3 of the unit, and yes, after covering these 3 unit, you have the practice of each and every of the units and their conceptual understanding of the questions. Now we are moving forward to the first question, that is your question number 1. First of all guys, please read the question and let me know what is the correct answer of this particular question as well. Yes, everyone. When I'm talking about the question is saying a statute. A statute creates a special tribunal for adjudicating a disputes and provides a complete mechanism including the appeal. So the civil court jurisdiction will be what? You know very well, in the class I was taken the example for your DRT, that is Debt Recovery Tribunal. You know na, DRT is your what? Debt Recovery Tribunal is a special type of court which was established by whom? Central government. So it's a special court for all the amounts which is exceeding by 20 lakh rupees, which is legally recoverable by a bank to any of the borrower. So they can simply be lodge a particular suit with the DRT, Debt Recovery Tribunal. So the civil court, they don't have any kind of jurisdiction where the special court have the jurisdiction. So can I say the special court is impliedly varied from taking any kind of jurisdiction in which already the special court have the jurisdiction and they have the power to adjudicate the matter. So that's why the reason option number C is absolutely the correct answer. Now we are moving forward to the question number second. Question number second in our screen, and this question is saying which of the following is not a condition for applicability of section 10 of the Civil Procedure Code, that is a stay of suit. So you all are required to find out which option is correct and which option is perfectly matching here in relation to the applicability of section 10 and at the time when we have a stay of suit. So which of the following is not a condition for the stay of suit? The first is identity of the cause of action, previously instituted suit is pending, the court must be competent to grant the relief, same matter directly and substantially in issue, and same parties or parties litigating under the same title. So what do you think right now? Please give your answer in the chat box. Which particular option is not a particular condition for the applicability of section 10 of Civil Procedure Code? Can I say the option number A is the correct answer? Yes. What is exactly stay of suit? Stay of suit is just like any kind of suit which is previously be instituted, but yes, right now it's not be resolved. So any kind of fresh suit is totally be stayed here. Now in case when the court is competent to grant a relief, this is also be the situation where we can impose the stay of suit. And when any of the matter which is already be pending, so further you cannot be raise any kind of action with the same cause of action and the same parties are litigating under the same title. So yes, any new party will not be raise any kind of complaint with any of the parties for which litigation already be under the same title is not resolved yet. So only the identity of the cause of action is not a condition for the applicability of section 10 of Civil Procedure Code. Now we have the question number 3, and the question number 3 is on our screen. So please read the question and let me know what is the correct answer of this particular question as well. This is your case study question, so give me the answer accordingly. Yes, everyone. Which option is correct right now? So the question is saying a suit is filed. A suit filed against the Mr. B in a Delhi for the recovery of 10 lakh rupees. While the suit is pending, B files another suit in a Mumbai seeking the declaration that he does not owe any of the money. Which of the following is correct? Can I say here we have the provision of res judicata? Yes, sir. So A filed a suit against the B in a Delhi for the recovery of 10 lakh rupees while the suit is already in a pending. So when one suit is not be resolved at all, so you will not be raise any kind of concern, you will not be file any fresh suit till there is any kind of suit is already be pending in one of the court. So can I say right now the Mumbai suit is totally be barred from the application? Yes, yes, absolutely. So the option number B is correct answer. Mumbai suit is totally be barred right now. So if you are selecting option number B, yes, your option is absolutely correct. Now we have the question number 4. Question number 4 is saying A own a land which is partly in Delhi and partly in Haryana. So A basically owns a land which is partly in Delhi and the partly in Haryana. Now he files a suit for the partition in the Delhi court. Now you all are required to tell me in the chat box which statement is correct. Which statement is correct right now, and as well as guys, please don't forget to like the session, because these type of questions you will never be find in any other of the platform, because these all the questions are quite important, as well as you can directly be find in your 10th of January 2026 examination as well, if you have the command on each and every type of question which right now I am discussing. Can I know which option is correct, everyone? So guys, the question is saying if A own a land in Delhi and partly in Haryana, he file a suit for the partition, so suit is not maintainable. Suit must be split. Suit maintainable only in Haryana. Suit maintainable only with the High Court permission, and suit maintainable in Delhi if the entire claim is cognizable. Yes, if the claim for this particular suit is already be cognizable, entire claim is cognizable, so you may file a suit in the Delhi rather than filing a suit in Haryana. So yes, can I say is right now the option number E is absolutely be correct? Yes, of course, option E is correct if your entire amount is cognizable in Delhi itself. So you can reach out with the Delhi court and where you can lodge a particular suit for the partition. So option number E is absolutely be correct. Now we have the question number 5 guys, and please read the question number 5. What is exactly the requirement of question number 5? The question number 5 is saying a decree was passed by a court lacking the territorial jurisdiction. No objection was taken during the trial. Later, a fresh suit challenged the validity of the decree passed by such court. What is the legal position right now we have? Yes, everyone. A decree was passed by the court lacking the territorial jurisdiction. You can take the example. Let's suppose Mr. X, who filed the case in Delhi instead of filing the case in Calcutta. But right now, the Delhi court, even though they don't have the jurisdiction, they resolve the matter. Later on, a fresh suit has been filed regarding the validity of the decree in Calcutta. So, can I say right now what is the legal position? So, the decree passed by such court is void, decree is voidable, court has the discretion, and the decree can be challenged and challenge be barred. So what do you think right now? Please give your answer in the chat box. What according to you is the absolutely be correct answer? So Mr. X, who filed the particular suit in Delhi, but instead of filing the suit with what? Instead of filing the suit with Calcutta. And right now during the trial, no one party has challenged the particular matter, and Delhi court basically resolved this particular suit. So right now at the time when the Delhi court has already be resolved the case, they suit and they have passed the decree. So can you challenge this decree? No sir. This challenge shall be barred. Right now option number E is correct answer. So even though Delhi don't have the jurisdiction, they have the lack of territorial jurisdiction, but in case they have passed the particular decree and that during the trial no party has raised the concern, so definitely the decree passed by the Delhi court is totally binding on both the parties. So later you can't be challenged against the decree passed by Delhi court just by the reason they have the lacking of territorial jurisdiction. Now we are moving forward to the question number 6. Right now you have the question number 6. So please read the question number 6 and let me know the correct answer as well. This question is saying a court award interest from the date of decree till the payment at the rate 12% in a non-commercial transactions. So let me know whether this interest is absolutely be correct or not. So the first statement is yes sir, is absolutely be valid decree or interest payment. No, it's invalid. It's void ab initio, valid if reasons has recorded, and valid only if agreed. So what do you think right now? Please let me know in the chat box. If the court award a interest payment from the date of decree till to the payment of the decree in case of non-commercial transactions, so this interest payment shall be valid or not? This is the absolutely very perfectly and amazing question. Yes guys, this particular interest payment is totally be invalid. Why sir? Because if I am talking about as per the provision of Civil Procedure Code 1908, the maximum rate of interest shall be leviable in case of from the date of decree to the payment of decree is 6% per annum. Yes, in case of non-commercial transactions, the court shall award maximum 6% per annum as an interest payment from the date of decree till to the payment of decree over here. That's why the reason here, if the court has passed 12% is totally be incorrect. So option B is the correct answer because it's totally be an invalid interest of payment. Now we have the question number 7, and the question number 7 is on our screen, and this question is saying which of the following is not a valid ground for arrest in the execution of money decree. So at the time of executing the money decree, let me know which of the following grounds is not valid for the purpose of arresting any of the judgment debtor. So the first statement is when judgment debtor is likely to abscond, judgment debtor is acted in a bad faith, judgment debtor has mean but refused to pay, judgment debtor is unable to pay due to the poverty, and judgment debtor transfer the property dishonestly. So what do you think right now? Please give your answer in the chat box. What according to you is the absolutely correct answer? Yes guys. Can I say when the judgment debtor is unable to pay the debt, so in such of the case due to the poverty he is unable to pay, so right now this is not with the valid ground you can arrest the judgment debtor while the execution of money decree, so that's absolutely be a invalid ground. So this is the reason behind it. If the judgment debtor is very poor and because of the poverty he is unable to pay the dues amount, so in such of the case you will not be arrested that particular judgment debtor. Now we are moving forward to the question number 8. Question number 8 is on your screen. So please read the question number 8 and let me know what is the correct answer. So I am reading the question to all of you guys. So a suit is filed in a court. A suit is filed in a court A. Now defendant applies for transfer under section 22 of the Civil Procedure Code. So one of the defendant who applies for the transfer of this suit filed by one of the person, that is Mr. A. Now the courts involved are subordinate to different high court. So right now those court who is a subordinate court which is basically have the high court but it's a different high court. So which authority is competent to decide the transfer application? So let me know in the chat box what is the correct answer right now dealing with your section 22 of Civil Procedure Code. So everyone please read the question very carefully and let me know which option is correct right now. Yes guys. So a suit is filed in the court A and later the court involved are subordinate to the different of high court. So in such of the case only the Supreme Court. Only the Supreme Court has the power to transfer this application and they will decide the transfer application. So definitely they can transfer the application with whom? With the Supreme Court, and the Supreme Court is competent to decide the transfer application. So if you are selecting option number C, yes, of course, your answer is absolutely be correct. Now we are moving forward to the question number 9. And the question number 9 is on our screen. The question number 9 is saying arrest of judgment debtor in a money decree is permitted only if. So right now let me know when a particular judgment debtor may be arrested in case of money decree. The first is if decree exceed by 2000, judgment debtor is a corporate entity, judgment debtor is absconding him only, judgment debtor has mean but refusal to pay, and judgment holder demands the arrest. Decree holder demands the arrest. So what do you think right now? Which option is absolutely the correct option, guys? Can I say right now, when the judgment debtor have already the money but he refuses to pay voluntarily? So when one person who refuses to pay voluntarily even though they have the money, so in such of the case such judgment debtor may be arrested by the authority. So can I say the option number D is absolutely the correct answer? Yes sir, option number D is correct answer. Now we are moving forward to the question number 10. This is again a very important question from your exam point of view. So please let me know in the chat box which option is, as per your opinion, is absolutely be correct. As per your opinion, is absolutely be correct. As per your opinion, is absolutely be correct. Yes guys, the question is saying opinion is absolutely who is a judgment debtor arrested at what? Yes guys, arrested at the question is saying opinion is absolutely who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Yes guys, arrested at what? Yes guys, arrested at the question is saying opinion outdoors who is a judgment debtor from his house. Now saying arrest of senior citizen. Arrest of what? Arrest of senior citizen. Arrest of what? Arrest of insolvent person. And arrest of agriculturist. Arrest of government servant. And arrest of woman in execution of decree. Guys, option number E will be correct. If you want to do the arrest of any of the women now, so yes, you can't be arrested in case of the execution of decree, because the civil procedure code is not be giving a power to the police officer for the purpose of doing arrest to any of the women. So at the time of executing of the decree, arrest of the woman is totally be prohibited as per the provision of civil procedure code. Now we are moving forward to the question number 12. And what is the question number 12, sir, we have right now? Question number 12 is talking about a decree for 3,500 is passed. The court order civil imprisonment of judgment debtor. Which of the following is correct? So what do you think right now? A decree for 3,500 is passed, but such court order the civil imprisonment to the judgment debtor as well. So which option will be correct? Option first is detention up to 3 months, detention up to 1 month, detention up to 6 weeks, no detention is permitted, and detention till the payment. So can I say the option number C will be correct answer? Absolutely yes, sir. So the maximum detention shall allowed, but up to the only 6 week of the time period, but not much more than that. Because in case when the decree is passed, guys, always be keep in your mind, when the decree is passed and the decree is not exceeding by 5,000 rupees, when a decree is not exceeding by rupees 5,000, so in such of the case, always be keep in your mind that the detention must be allowed only up to the 6th week, but not much more than that, because the decree amount is only by 5,000, up to the 5,000. So question number 12, we have the option C is correct answer. Now we have the question number 13, and this question number 13 is on your screen. So please let me know which option is absolutely be correct after reading this question. This is again be a case study question right now you all have. Yes, everyone. Can I say what is the question requirement? The question is saying property sold in the execution on 1st of March, which sale is confirmed on 1st of April. So the ownership shall be passed on which of the date? Guys, it doesn't matter at what time period the sale will going to complete, because how the sale will complete, sir? Sale will complete when both the party will execute the document, when the buyer must be pay the particular price to the seller, only then the sale will be confirmed, like somehow advance amount like this. So when the property is sold on execution on 1st of March now, so the what is the date of selling of the property? The date of selling of the property is 1st of March. So from the date of selling of the property now, the ownership of that property shall pass to whom? Pass to the buyer over here. So can I say the option number B will be correct answer? Even though you have the possession of immovable property, you have the possession of property, but once a property of sold is executed on 1st of the March, so definitely you are not be entitled to any of the ownership, because on that date the next new buyer will become the owner. So option number B will absolutely be correct answer. Now we have the question number 14. Again, this is a very important question. So please read the question and let me know what is the correct answer of this question as well. Yes, guys, have you read the question? What is the question requirement is? The question is saying at the time of execution of decree, the following properties of Mr. X are sought to attest. Now you all are required to identify which of this property is. The first is his agriculture land used for livelihood. So guys, this property you will not be execute at the time of execution of the decree. So this property will not be attached at all. Attached means taken a possession, and after realizing the property, return back your money as well. Now the second is his residential house in a village. So on a residential house, again there will be no any kind of attachment order shall passed by any of the court. Now his bank account containing the 3 lakh. Now this is the correct statement, because if in your bank account, if there is a still a credit balance you have, so at the time of executing a decree, yes, your bank account shall be taken care of at the time of setting of the transaction. Now we have Professional tool as a carpenter, again this is a personal property, and the personal property will not be attached at all. Government pension credited the per month, we have already been covered in the class. If any of the person who is receiving a government pension, so that government pension credit amount shall not be attached for the purpose of realizing the property for which one of the person has taken a loan. So only the third number statement is correct answer, because his bank account containing the 3 lakh rupees. So on that particular credit amount, yes, there is a court has the power to attach this bank account over here. So can I say the option number C, that is third only statement, is correct? Yes, of course. So if you're selecting C option, yes, your answer is absolutely be correct. Now guys, we are moving forward to the question number 15, and the question number 15 is on our screen. So first of all, read the question and let me know what is the correct answer of this particular question as well. Guys, have you read the question? What is the question requirement? So the question is saying A, B and C, they basically hold the money decree. They hold the what? They hold the money decree against Mr. X. A applied for the execution on 1st of March. So right now A, B and C, these three party have the money decree. But you know very well you have to apply for execution, only then you will able to receive the amount mentioned in the money decree. Apart from it, when I'm talking about B also be applied. B applied on which date? B applied on 5th of March. But property sold on 10th of the March. But right now property was sold on 10th of the March. But A and B, they have basically applied the decree, money decree, on the 1st of March and the 5th of March. But C applied on what? C applied on 15th of the March. Which of the following statement is correct, guys? Definitely right now, can I say the application is after confirming the sale? Yes, na. After we have sold the property, then you are applying for the money decree, so then you are not be eligible. You are not be eligible if you are delaying in giving the application for the money decree. So once the property was sold, after the property sold, any person who is claiming any of the amount and they want to execute the any of the application for the purpose of receiving the money decree, so that person is not allowed at all. So can I say who has given the application for the execution of the decree? So only the Mr. A and the Mr. B, these two party has given the application for the purpose of executing of the decree. So can I say right now only A and B will absolutely be correct answers. Only they will share the particular property and the money which will going to receive after realizing the property over here. Yes, of course. So the option number B is absolutely be correct. Now we are moving forward to the question number 89, and this question is saying in case of dispute referred to the Lok Adalat under section 89 and the parties have basically arrived at the settlement, so one party later on challenged the settlement on a matrix basis. So right now, can I say right now this challenge shall acceptable or not? So which is the legally correct? What do you think right now? Please give your answer in the chat box. The first statement is saying appeal must lie. No appeal lie, but you can be do the revision over here. Writ lies. Settlement is final and the binding. Settlement require the court confirmation. So what do you think right now? Please give your answer in the chat box as well. Yes, everyone. Can I say right now, in case of any of the award passed by Lok Adalat, so that award is always be binding, and no person will raise any of the concern and they will not be file any of the application with any of the court in case the Lok Adalat pass the any of the decree over here. So can I say the option number D is absolutely be correct? Yes, sir. So if you are selecting option number D, your answer is absolutely be correct over here. Now we are moving forward to the question number 17, and the question number 17 is on our screen. Please read the question very carefully and let me know what is the correct answer of this question number 17 as well. Yes, everyone, what is the correct answer? The question number 17 is saying a primary decree is passed, but party does not file an particular appeal. But later, when the final decree is passed now, one of the party has basically raised a concern and they filed an appeal challenging the findings of preliminary decree. Let me know, is it this correct, sir? Guys, when I'm talking about the decree now, you know very well that we have the two type of decree. One is a preliminary decree and the second one is a final decree. Preliminary decree is passed before resolving the disputes. So, before resolving disputes and during the trial, before resolving disputes and somehow you can say during the trial, this kind of decree shall be passed by the court. But when any of the preliminary decree passed by the court and during the trial, if you have not be raised any of the objections, so further when the later on final decree has been passed after deciding the matter, you will not be raised any kind of question or challenge the decree passed under the preliminary decree. That's the reason behind it. If you have the objection, you can file during the trial. So during the trial, if there is an objection, so that objection you may file an appeal. So the appeal will be considered here. But once the final decree has been passed, now if you want to challenge the preliminary decree, that's not be allowed at all. So that's the reason behind it. Can I say the appeal be varied, appeal be maintainable, court may condone? They depend upon the court discretion, apply only on the law? No, sir. This is appeal and this appeal is totally be varied. So when a preliminary decree is passed, later on the final decree has also be passed. So you will not be raised any kind of objection when already the later final decree has been passed by the court. So can I say the option number A will be absolutely be correct answer? Yes, sir. Now we are moving forward to the question number 18, and this question is talking about which of the following is a substantial question of law. So you all are required to find me out here the substantial question of law. So please give your answer accordingly. Yes, guys. What is the correct answer? The first statement is saying trial court wrongly appreciate the evidence, witness credibility wrongly assess, legal principle wrongly applied, incorrect valuation of the evidence, wrong interference of the fact. So yes, what do you think right now? Can I say when the legal principle wrongly be applied? Let's suppose we have the two of the person who have a particular dispute. Let's suppose we have the dispute between Mr. A and the Mr. B. Right now it has been proven that Mr. B makes a default on the specific what due date, but in such of the case at the time when the Mr. A has makes a default on the specific due date, so let's suppose the trial court passes the order. In this circumstances, trial court pass the what? Pass the order. So when any of the order passed by whom? Passed by the trial court. So guys, let's suppose this particular trial court has passed the particular order or a decree in one of the section which is more severe. Let's suppose at the time of passing the decree they have taken the reference of what? They have taken the reference of section 420A, section 420 of Civil Procedure Code, But right now this matter is not belongs to the section 420 of the Civil Procedure Code. This matter belongs with the 410 of the Civil Procedure Code. So when we have any kind of substantial question of the law now, so the legal principle which is not be applied perfectly or which is wrongly be applied, that will become your what? That will become the question of law over here. So can I say the option number C is absolutely be correct answer? Yes, sir. Now we are moving forward to the question number 19. And this question is saying, a decree is passed against the Mr. X and Mr. X dies leaving behind. So after the death of Mr. X, in the name of Mr. X, we found some of the property. The first is son who inherited property, daughter who did not inherit, wife who received the money gift, decree holder seek the execution. So what do you think right now? Please let me know in the chat box what according to you is the absolutely be correct answer. That is, execution can against all the legal heir, execution can against only the son, execution against only the wife, execution will remain buried, and execution only against the property inherited. So what do you think right now? Which option is absolutely be correct, guys? Can I say right now, in case when the X leaves behind and a decree is passed against the Mr. X, so in such of the case, when I am talking about the question number 19, the son who has inherited the property, can you tell me in the chat box this inherited property is belongs to right now the legal representative of the Mr. X, that is son who inherited the property. They have basically what? They have basically the right, and right now this property belongs to the Mr. X. So after the death of Mr. X, generally the execution shall be made at the son who inherited the property. So the first statement, that is the statement number 1, is correct answer. But the daughter who did not still inherit, how you can execute a particular decree against the daughter who didn't inherit any of the property of Mr. X over here? Wife who received the money gift, again sir, ye money gift is just like a personal kind of things. Money gift is not be a property for which you can enforce the decree. That's why the reason behind it, option number E will be the correct answer. The son who inherited the property after the death of Mr. X na, only against this property, yes, the execution shall be made. So execution shall be made only against the property inherited. So if you are selecting the option number E, yes, your answer is absolutely be correct, guys. Now we are moving forward to the question number 20. And this question number 20 is talking about a decree for the partition of agriculture land assessed to a revenue is passed. Which of the authority will execute the decree? So now guys, please listen the question very carefully. The question is saying a decree for partition of agriculture land assessed to revenue is passed. Now in such of the case, who has the authority to execute the decree? The first is civil court, second is district judge, third is revenue officer, fourth is collector, and the fifth one is either C or D. So what do you think right now? Can I say in such of the case either the revenue officer or either the collector? So again you will not be allowed to arrest the same person for the same kind of decree. So re-arrest is totally be buried. So guys, always be I'm saying strong your concepts. If your concepts are strong, everything is very doable. You can participate the question as well as you can solve any of the question in your exam in a very convenient manner, in a very quickly manner. And for that purpose, you can refer my notes, conceptual notes, and these notes you will find in the Oliveboard application under the SEBI Grade A complete course. If you will just go through with my notes now, you have the still conceptual understanding of each and every kind of concepts. If you have any kind of doubt, query, you can further reach me out at this Telegram channel, Chartered Ajay Thakral, and you can simply scan this barcode as well. Now guys, we are moving forward to the question number 22. And this question is saying, A has the decree in 2021. Okay. So generally we have the three of the person and they have the decree in a different time period. B has the decree in 2022 and C has the decree in 2023. So we have the three of the parties, and these three of the parties have the decree in different time of the period. Now the property sold in 2024, only B and C applied for the execution before the sale. So right now I want to know from all of you who will get the share. Who will get the share in such of the question number 22? So in question number 22, who will get the share? So if you want to apply for the execution of decree na, so the application must be before the sale of property. So yes, any person who want to apply for any kind of execution, so the application must before the sale. And if you are not be making the application before the sale, you are not be eligible to take any of the share in the property sold of the proceeds. So always be keep in mind, if you want to give an application before the sale, only those parties are eligible to get the share from this property sold over here. So when the property sold in 2024 and already Mr. B and the C, they have applied for the execution of decree before the sale, so these person are allowed in the share of this property sold over here. So the option number C is absolutely be correct. Now we are moving forward to the question number 23, and this question number 23 is saying which of the following statement is correct regarding the decree executable against the government. So if one of the parties who want to execute a decree against the government, so let me know which of the following statement is correct right now. The first statement is saying decree against government executable immediately basis. The execution needs the president's sanction. The decree executable after the 30 days. Decree executable after the 3 months, and execution barred the permanently. So what do you think right now at the time of executing the decree against the government? Yes, if you want to execute the decree against the government, you all are required to give a proper notice to the government, and after giving a proper notice, the decree executable after the 3 months. So you must be give at least 90 days of the notice, and after giving a proper notice, yes, whatsoever the decree you want to execute, definitely you can execute, but after the 3 months. That's why the reason option number D is absolutely be correct. Now we are moving forward to the question number 24. This question is saying which relief cannot be granted under section 92. So let me know which of the below of the following you have the 5 option, and which option is perfectly matching here, where you will not be grant any kind of relief under section 92. The first is personal damage, removal of trustee, settlement of the scheme, recovery of the possession, and appointment of the trustee. So what do you think right now, which of the following relief cannot be granted under section 92 over here? Everyone, can I say right now the option number A is correct answer? If I have any kind of personal damage, so for personal damage, you will not be asked for any kind of relief. Definitely for a personal kind of damages, no relief shall be granted as per the provision of section 22 under the Civil Procedure Code 1908. So this section 19 is belongs to your Civil Procedure Code 1908. Now guys, we are moving forward to the question number 25, and this question number 25 is saying which of the following is not a substantial question of law? Sir, what is question of law generally? First of all, read the question, then I will explain you what is the question of law. The first option is wrong interpretation of the statute. It's a question of law. It's not a question of law. Incorrect application of the legal principle. It's not a substantial question of law. Wrong appreciation of the evidence. It's not a substantial question of law. Or ignoring the binding precedents and the jurisdictional error. So which of the following is the absolutely correct answer at the time when I'm talking about which of the following is not a particular matter at the time of deciding whether it's a question of law or not? So can I say right now, if one of the court has interpreted this any of the provision of any of the act in a different manner, but you are saying this interpretation belongs to different thing. So this matter will become the question of law, and you can directly approach with the High Court or a Supreme Court if you have the question of law at the time when the one of the court has taken a wrong interpretation. Incorrect application of the legal principle, again it's a question of law. Yes, you are saying this legal principle will apply, but the court has applied the incorrect application of the legal principle. Again, for this question of law, you can approach with the High Court or a Supreme Court. But for a wrong appreciation of the evidences, so wrong appreciation of the evidences, you can file an appeal. So this is not a question of law. This is not a question of law. If you think that this particular appreciation of the evidence is a wrongly way, so you can definitely file an appeal, you can definitely challenge the decision, but it's not a question of law. So that's why the reason behind it, option number C is absolutely be correct. Now we are moving forward to the question number 26. The question number 26 on your screen. So let me know which option is correct right now. And the question is saying, which power does the appellate court not have? What do you mean by, sir, appellate court? Appellate court is that court where we are filing an appeal. So let me know which of the following power has not granted to the appellate court over here. The first is remand, second is grant relief, not paid, take the additional evidence, frame the issue, determine the case finally. Guys, when I'm talking about the appellate court, they have the power to take a remand on particular matter, take additional evidence in order to resolve the particular dispute, frame the issues as per their own discretion, and determine the case finally, because these are the power has been given the appellate court, so they have the jurisdiction. But granting a relief for which the parties have basically not be paid, so this is the power has not been given to the appellate court. So if the appellate court granted the relief for which any of the party has not paid, so that is not the power of appellate court. So generally option B is the correct answer, because appellate court doesn't have the power to grant the relief which is not paid. Now we are moving forward to the question number 27, and this question number 27 is talking about in a second appeal. In a second appeal, the High Court finds that the lower court ignored a material issue, evidence on record is sufficient, and no further evidence is required. So can you tell me in the chat box, what can the High Court do? In such of the circumstances, what can the High Court do? So in any of the second appeal, if the High Court found that the lower court ignored a material issue, evidence of record is sufficient, and no further evidence is required, so in such of the case, definitely can I say the High Court has the specific power to decide the matter as individually? Definitely yes. So by own discretion they can resolve the matter as well. So remand the case compulsory, dismiss the appeal, refer the matter to the trial court, but decide an issue itself. So if the High Court want to decide the matter itself, they can do. Yes, we have given the power. Civil Procedure Code has given the power to the High Court. If the lower court ignore a material issue, the sufficient evidence for that particular issue has been available and no further evidence is required. So definitely the High Court will proceed this matter and they will pass the decree accordingly. So the option number D is absolutely the correct answer. Okay, now we are moving forward to the question number 28. And what is the question number 28 is talking about? This question is saying a party did not appeal against an interlocutory order. So a party did not appeal against the interlocutory order. Later, while appealing the final decree, the party challenges the order. So which statement is correct right now? For the similar, we have already covered the similar type of questions in the previous of remaining 27 questions. So I think right now you can easily give the answer in a very amazingly manner. So when a party does not appeal in an interlocutory order, later while appealing the final decree, the party challenges that particular order. So which statement will remain correct? Challenge not allowed, challenge allowed only with the court permission, challenge allowed only if the revision, challenge automatically be buried, and challenge allowed if the error defect decision. Guys, the challenge shall only be allowed if there is an error affect the decision. Otherwise the challenge shall not be allowed at all. So while appealing the final decree, so if any of the party who want to challenge the order na, and if that particular decision has influence with some of the error that will affect the decision, only then the challenge shall be made. Otherwise the challenge shall not be allowed at all. So if you are selecting here option number E, yes, we can say the option number E is absolutely be correct. Now we are moving forward to the question number 29, and this is the question number 29. So please read the question and let me know what is the correct answer. The question is saying which condition must exist for the joinder of plaintiff. Yes, the question is saying what? The question is saying which condition must exist for the joinder of plaintiff. So if one or two of the plaintiff they want to join together, which conditions they all are required to satisfy? The first is same relief, the second is same cause of action, third is same residence, fourth is same lawyer, common question of law or the fact. When I'm talking about the joinder of the plaintiff now, they must have the same cause of action. Like I was given you the example during the class that in case one of the parties aggrieved by the decision or any kind of statement passed by one of the party, like a defamatory sentence, if one of the party has passed a defamatory sentence for one of the particular community, so any of the person who has right now affected with this statement, they can definitely join together and they lodge a complaint against that particular person. So when we have the same cause of action now, so one or two of the plaintiff they can definitely be joined together. So option number B is absolutely be correct, guys. Now before moving ahead to the question number 30, first of all I want to say only one thing, guys. Always be strong your concepts, because if your concepts are strong now, you can solve any of the question in your exam as well as during the practice set question. But if your concepts are weak, you will definitely find a problem during your examinations and on 10th of the January 2026. So always trying to be strong your concepts. Apart from it, if you want to get my conceptual notes, you can directly reach me out at this Oliveboard application at the SEBI Grade A complete course, where you will find all the conceptual notes. So if you will go through with all the conceptual notes now, you can then solve any of the questions. Now if you have the any kind of question, if you have the any kind of you need a clarity on the any of the provision, you can directly reach me out at this Telegram channel. So just you can search this barcode, or else you can search this Chartered Ajay Thakral at the Telegram channel. Definitely I will help you with any of the questions, and definitely I will provide you whatsoever the e-PDF notes you want. Now we are moving forward to the question number 30. We have the question number 30, and this question is saying a suit is filed against the government. So one of the suit is filed against the government without any kind of notice. So the suit is filed against the government without any kind of notice. So the first statement is court grants an interim injunction. Later court finds no urgency existed. So what happened in these circumstances? When a suit is filed against the government without any kind of notice, so court grants interim injunction and later the court find no urgency existed. So what will happen right now? Suit will dismissed, plaint returned, injunction remains, decree become void, and the case shall transfer. What do you think right now? So when I'm talking about the option number B is correct answer. The plaint shall be returned. So if you have not been given any kind of notice to the government, if you want to file a suit against the government, so in such of the case, yes, the court shall grant an interim injunction and your plaint shall be returned. Till you have not been given a notice to the government, you will not be raised any kind of suit against the government over here. That's why the reason, if the court finds there is no urgency existed, so definitely they will return your plaint. So option number B is absolutely the correct answer. Now we are moving forward to the question number 31. And again, this question is your case study question, so you can mark this question very important. You will definitely find in your exam. So the question number 31 is saying a suit is pending. A suit is pending before a foreign court between the same parties on the same issue. So one of the suit which is pending before a foreign court between the same party on the same issue. Now a fresh suit is filed in India. So what will be the legal position? What will be the legal position when one of the suit which is already be pending before any of the foreign court between same of the parties on the same issue, but right now one of the party has lodged a fresh suit in India. So what will be the legal position? The first is Indian court must stay the suit. Indian court has discretion to stay. Indian court cannot be proceed. Indian court can proceed. Indian court must dismiss the suit. So what do you think right now? Please give your answer in the chat box. What according to you is the absolutely correct answer for this particular question? Yes, everyone. Please let me know in the chat box which option is correct. Can I say right now the Indian court can proceed with the suit? Absolutely yes. The Indian court will not dismiss the suit. The Indian court has the power to proceed this particular matter. So if any of this suit which is pending before the foreign court between the same parties or the same cause of action and any of the person who filed a fresh suit in India, so definitely Indian court has the power to proceed with this particular matter as per the Civil Procedure Code 1908. So the option number D will be absolutely correct. Now we are moving forward to the question number 32. The question number 32 on your screen, and this question is saying a suit was filed in 2022. A suit was filed in 2022 and decided in 2024. Another suit is filed in 2023 on the same issue which is pending. Now let me know what is exactly the meaning of former suit. What do you stand for here, former suit? What do you think right now the correct interpretation of former suit? Can anyone tell me in the chat box what is the former suit? A suit filed earlier, a suit decided earlier, a suit pending earlier, suit with a higher pecuniary value, and suit decided by the superior court. So what is exactly the interpretation of former suit? Definitely yes. Option B is correct answer, because you can see right now in 2024 already the matter has been resolved. Already the matter has been decided. So it's become a former suit and you want to lodge a particular suit on the same issue which is a pending. So which principle will apply? Res judicata principle will apply. So suit decided earlier, this will become a former suit. Now we are moving forward to the question number 23. The question number 33. And this question number 33 is talking about a suit for foreclosure of mortgage. A suit for foreclosure of mortgage of immovable property shall be instituted at what? Suit for foreclosure of mortgage of immovable property shall be instituted where the plaintiff resides, where the defendant resides, where the property is situated, where the cause of action arose, and where the mortgage deed was executed. So what do you think right now? Which of the following option is absolutely correct as per your knowledge? So please let me know in the chat box which option is correct. For the suit for foreclosure of mortgage of immovable property shall be instituted at the place where the property is situated. So you will lodge a particular suit at this place where a property is situated. So if you are selecting here option number C, yes, of course your answer is absolutely be correct. Now guys, we are moving forward to the question number 34. The question number 34 on your screen. This question is saying a defamation is committed. Defamation is committed in Kolkata. Defendant reside in what? Defendant reside in Delhi. Now the suit can be filed at what place? A defamation committed in Kolkata, defendant reside in Delhi. So if you want to file a suit against this defamation, so at which of the particular place you will definitely file a particular suit? So the first option is only in Kolkata you will file a suit. Only in Delhi you will file a suit for the defamation. either the Kolkata or a Delhi, you can file a suit only where the plaintiff is resides and where the publication occurred. So what according to you is the absolutely correct answer? Can I say either you can file a suit in a Kolkata or either you can file a suit in a Delhi? Absolutely yes. So it doesn't matter you want to file a suit in a Kolkata or you want to file a suit in a Delhi, you have the option to file a suit in the Kolkata or Delhi itself. So if you are selecting your option number C, absolutely your answer is correct. Now guys, we are moving forward to the question number 35 and the question number 35 on your screen. So what is exactly this question is saying? This question is saying consider the following statements. Consider the following statement regarding the joinder of plaintiff. So yes, you know very well, when we have the same cause of actions, two or more of the plaintiff can join the case simultaneously and directly be lodged against the defendant over here. So now we have the question number 35 and the first statement is related with your joinder of the plaintiff, and the first statement is saying all the plaintiff must have the identical cause of action. No guys, it doesn't matter at all you have the identical cause of action or not. There may be the identical, not identical cause of action, but yes, when I'm talking about, yes, you have specifically same concern, the identical type of suit if you have, then you can definitely join the particular suit. But for identical cause of action, this is not the provision for at the time of filing a suit under the joinder. Second statement is talking about a plaintiff may join if they have the common question of law or the fact arise. Yes, this statement is true. If we have the common interest, if we have the common case, if we have the common suit, if we have the common question of the law, then we can definitely be joined together. The third statement is court may order a separate trial if the joinder cause embarrassing or delay. Definitely it's a true. If two or more of the plaintiff want to join in a particular kind of suit, but the joining of one of the plaintiff it cause a delay, so definitely the court may order you can file a separate trial if the joinder by negligence or by voluntarily, if they are delaying the proceedings, so the court may pass an order for the separate trial. So this statement is again be a true. And the last statement is talking about the joinder is mandatory if relief claim is similar. No guys, joinder is not be mandatory at all. Yes, the joinder may, it's a optional. If you want to get a relief that is totally be similar, so you may join with one of the particular suit, but it's not a mandatory that you must be joined in one of the particular suit where you have the same question of law or where we have the same fact arises. So that is not a mandatory. So we have the two statement is correct. Can I say the option number A is absolutely be correct? The statement second and the third is absolutely be correct here. Yes sir. Now we are moving forward to the question number 36. The question number 36 is on your screen. So first of all, read the question number 36 and let me know what is exactly the correct answer. The question number 36 is talking about with reference to the representative suit. With reference to the representative suit, consider the following statements. The first statement we have right now, that is permission of the court is mandatory. Permission of the court is what? Permission of the court is mandatory, the first statement. The second statement is notice must be given to all the interested person. Consent of all the represented person is required. Decree passed bind all the person represented. So in case of representative suit, please let me know in the chat box which of the following statements are true. The first statement is talking about yes, the permission of court is definitely it's a mandatory. Yes, if with reference to the representative suit now, yes, the permission is required to be taken from the court. The notice in case of the representative suit, let's suppose I want to file a case on behalf of 100 of the similar interest people. So it's become representative suit. So I require to give a proper notice. I require to give a proper notice that on behalf of this 100%, I want to file a suit against this particular person. So the notice is mandatory to all the interested person against whom I want to file a case with any of the person. Now consent is required. This is not be a true. You are not be required to take on a consent to each and every of the represented person. Just you are required to give a notice. The notice is more than sufficient, but you are not be required to take on a consent from each and every of the interested person. And the decree passed, definitely yes. If the court has passed the decree, so that decree shall be applicable and that is totally be binding to all the represented person. So when I'm talking about right now, we have the three statement that is absolutely be true. And which of the following statement is true? Like your first statement, second statement and the fourth statement. So if you are selecting here option number B, yes, of course, your answer is absolutely be correct. Now we are moving forward to the next question. And this question is talking about which of the following statements are correct right now. The first statement is saying if the plaintiff does not appear, suit may dismiss. Definitely, if I want to file a suit against you and after filing a suit, if I will not be present in the court, definitely the suit shall be dismissed. Definitely yes, na. But if the defendant will not be present, the court has the power to pass a ex parte decree. But yes, if I am filing a particular suit against the defendant, so definitely my presence is quite important. And if I will not remain present, definitely the court shall dismiss my particular suit. So this statement is absolutely be true. But yes, if the defendant does not appear, in such of the case, the ex parte decree shall be passed. This statement is true. Ex parte decree is what? Whatsoever the provision, whatsoever the matter exactly saying by the plaintiff, we will consider that matter is absolutely true on the basis of the hearing of one party. When the court has decided the matter, it's become an ex parte decree because the defendant has not be appear in front of the court. Now we have the third statement, ex parte decree can be set aside on a sufficient cause. Yes, if you have the sufficient cause and if you will explain the sufficient reason that this is the reason I will not be available at the time of issuing the summons. So if you have the sufficient cause like minority, like military duty, like imprisonment, like you are unsound mind during the time of the trials. So in such of the case, if you have the sufficient cause, then the ex parte decree shall be challenged and can be set aside. The appeal is only remedy against the ex parte decree? No, sir. Only appeal is not a remedy. You can claim a different remedy as well. You can challenge the particular dispute suit. You can also give a review application, but only the appeal is not a solution. You must give a sufficient reason why you have not be appeared, and after you have given a sufficient reason and the court will consider your reason, definitely they will pass the decision accordingly. So the first three statement is absolutely correct. Can I say right now the option number C is the true answer? Yes, if you are selecting here first, second and third option, it means the third statements. So initial three statement is correct answer. It means the option number C is absolutely be correct. So yes guys, finally successfully we have completed the each and every important sections and the rules of order of Civil Procedure Code 1908. Today we have spent almost 1 hour 20 minutes and we have solved the almost 37 type of questions. And this type of questions I think right now have given you the immense confidence about the each and every of the provision. So if you like the session, I request to all of you guys, please do like the session as well as share with your friends and the colleague, those who are preparing for SEBI Grade A legal stream. And definitely these sessions are quite important to all those aspirants. So I request to all, please do share with that aspirants as well. If you like the session, definitely you can click the thumbs up button and like the session as well. Apart from it, if you want a conceptual note, yes, you can directly reach me out at this Telegram channel, as well as you can directly be reach out at the Oliveboard application. If you want a conceptual notes, directly you can reach out the Oliveboard complete course, and in the complete course you will find all the classes access, all the regular conceptual notes, as well as you have also the paper number 1, paper number 2 mock test. So at the last 9 days you are also required to just go through with the important concepts. Just do the practice and practice of lots of the question whatsoever you can do, because you have left only 9 days. So you can utilize this time in a perfectly manner. Only then you will be able to clear your phase 1. Otherwise you will not able to clear the phase 1. Thank you so much guys. If you like the session, do like the session, as well as if you want to connect with me 24/7, you can directly reach me out at this Telegram channel, and for that purpose you can scan this barcode, and if the barcode is not be scannable, just you can search the Chartered Ajay Thakral on your Telegram channel. You will directly be find my official Telegram channel where you can ask any of the question. You will find any of the e-PDF notes related to any of the question. I will say only one thing, stronger concepts. Earlier, those aspirants have taken the selections. Definitely, your turn will definitely become. But these results are only be possible when you have the conceptual understanding. Because whatsoever the results right now you are seeing, now thousands of these selections, this is possible only because of the conceptual understanding. So I will say only one thing, stronger concepts. Because if you have the strong command on the concepts, anything can be feasible. And yes, you can solve any of the question. But if you don't have the strong conceptual understanding, you may find a problem while solving any of the question in your SEBI Grade A exam. For this type of competitive examination, no, you all are required to give only and only one focus, that is focused on the concepts. If your concepts are strong, everything is doable. But if your concepts are weak, definitely the SEBI will trap you in any of the questions. So thank you so much for the today's session. I think right now you have enjoyed the session. So don't forget to like the session as well as to share with your friends, and tell me in the chat box what's your marks. Out of the 37 questions, what exactly you scored. So please let me know in the comment box as well. And if you want to check out the Oliveboard complete course, you can simply search the Oliveboard on the Google Chrome. And when you will go at the Oliveboard Google Chrome, just select, after logging, just select the regulatory category. And once you will select the regulatory category, you can find here the SEBI Grade A complete course for the phase 1 as well as the phase 2. You will find here each and every of the conceptual classes. All the classes has already been available for legal stream, for paper number 1, paper number 2, your English, quant, reasoning, revision session. Each and every pack you will find here. Apart from it, you will also find the mock test for your practice of each and every of the concepts. So just subscribe this particular course, and at the time of subscribing the course, you can just use my coupon code AZAY. If you use the coupon code AZAY, you will get the 60% off. This is a new year off, so make sure you can definitely use my code AZAY, and within the price of 4399, you have the access of all the conceptual classes, all the mock test paper, and as well as all the paper number 1 and the paper number 2 content. So that's all about the today's session. Just let me know what's exactly your score out of the 37 questions. And if you like the session, do like the session and share with your colleagues. We will meet in the next session. So definitely, yes, Telegram channel. In the Telegram channel, I will upload this e-PDF notes. So in this Telegram channel, I will upload the e-PDF notes. So just scan this barcode. I will upload the e-PDF notes only on this Telegram channel. So make sure in this Telegram channel, you all must be joined, and I will upload these e-PDF notes after the over of this session. So we will meet in the next class by covering the remaining important questions of the Constitution of India. So we will meet in the next class. Till then, take care. Thank you very much. Once again, a happy new year to all of you guys. Bye bye to all of you.